welcome to everyone for our first Kazzie Connect for the year. I'm Lena Coates and I'm now Vice President of the KAV, which I'm really thrilled about. But tonight we've got Justin Mastores, who is the President of the KAV, and Nicolas Zervos, who is Principal of Zervos Lawyers, joining us to talk all about wills, estates and trusts, a very complex area. Now, before I get to introduce both those gentlemen, I just wanted to run through a little bit of housekeeping in that make sure that you're muted, and certainly, if you can, wait to ask questions at the end of the session. Now, everything, if Justin, if you'd kindly, before I introduce you, just run through the disclaimer for us, that would be wonderful.
Yeah, I will. Okay. If we can have that up on screen, I think Karen will put that up on screen. We'll just let everyone know that tonight the presentation that we're giving is of general nature, and it's not meant to be a recommendation or specific advice for people. So I think if anybody has any questions, what the information we're giving is obviously to the network of the Kazzie Lawyers Association and the members of the Kazzie Club of Victoria, but you should always seek advice from specific legal practitioners or professionals, financial advisors and accountants if you have specific questions relating to your needs. So the Kazzie Club makes no representations about the information we're about to give, and it's as I said, recommended that you seek your own advice if you have other questions beyond tonight.
Okay, wonderful. Now, Justin is our new president, and he leads a team of professionals who provide their clients with comprehensive advice, not just business and taxes. Rees is a boutique advisory firm with a focus on small to medium-sized and family groups. Justin will give us his view on the topic tonight, and then joining him is Nicolas Zervos. He's Principal of Zervos Lawyers and the KAV's legal representative on all our legal matters. Nicolas is a highly regarded, respected specialist lawyer in the areas of hospitality, liquor licensing, gaming and commercial law, and he was admitted into practice in 1980. So we'll get started now, and I've got a series of questions for you guys, and I'll leave it up to you both to decide who'll answer the question. So the first one I've got, which I'm sure a lot of people would be wondering, is when should you start to make a will, and why should you make it?
I'll start, Lena, and thank you very much for the introduction and the invitation. A will document can be made at any time. It really depends on one's circumstances, and obviously it is all about how you distribute your assets or liabilities, for that matter, to those that you wish to benefit. So it's very common for most people to start.
Unmute. It's unmute. Can't you hear it?
Sorry.
On mute, yes.
So it's very common for people to start drawing wills in their midlife rather than their early life, given that they've established families or they've accumulated assets, and they want to make sure that those assets are then directed to the beneficiaries that they've chosen. So there's no specific point in time. It's really a question of circumstance, although it is always preferable to start considering a will document when you feel that you're at that stage. What's important also is that just because you do a will, it doesn't mean that you forget about it. Will documents should be reviewed from time to time, depending on the circumstances.
Terrific. So what's the difference between a simple will that, you basically can write on a piece of paper and have it signed, or go to a solicitor or to have done, and a testamentary trust?
Well, first of all, a simple will, you'll find that most solicitors talk about a husband to wife or partner to partner, and if the partner fails to survive, then to the children. It's basically a document that needs to be witnessed by two people and also executed with the same biro or pen which still occurs to this very day. A testamentary trust, as you call it, is a separate type of document. What that is it basically, you can create, as most people may be aware of, a discretionary trust or a family trust. You can create that type of arrangement under a will, and that's what they call a testamentary trust. So instead of giving the asset directly to the beneficiary that you will under a simple will, under a testamentary trust, what you do is you create a trust in which the nominated beneficiary enjoys the benefits derived from that trust.
Let me just comment, Lena, about testamentary trust wills, and we see them in application, is that generally speaking, if somebody has a lot of personal assets as opposed to assets that sit in trusts or other structures or superannuation, if someone has a lot of personal assets, so we had a client, she was based in South Australia actually, and she was unwell about 3 years ago. So we had a will redone to what was a testamentary trust will because she had tens of millions of dollars of property assets in her personal name. And what then happened, the trust is created, my understanding, on the date of the person's passing. And so because she'd revised her will and had this testamentary trust will, the day that she passed away, this trust was formed, and these assets then essentially sit in the testamentary trust rather than the estate and going out to everybody. And then the beneficiaries, depending upon how the intention is worded, can run this testamentary trust, if you like, or call it, I used to have clients that like to call them buckets, but it's a bucket of assets that can then distribute to beneficiaries and even in some cases to children. So it's a way of controlling and keeping assets together that sometimes, if there's, especially Greek families like to keep the assets together rather than sell them off, but it's a way in which to do that. So again, you'd need to take specific advice on that, Lena, but it's more complicated. But generally, if there's more in the pot, it's sometimes a way in which people restructure their will.
Does the testamentary trust make it less contestable?
No, it's a simple answer. If a beneficiary feels that they've been not well looked after under a will, whether it's a simple will or a testamentary trust, it does not prevent them from seeking to make a claim to adjust that will.
Okay. A lot of people get confused in that by having a trust, they seem to think that it's uncontestable. I'm glad you clarified that. So what's the executor's role in a will, and can you have joint executors? And how many can you have?
Well, generally speaking, the executor's role in a will is very important because their role starts the day after the person has passed away. And they've got a legal obligation to call in the assets and liabilities of the estate and to complete the application for a grant of probate, as it's called, for the purpose of basically following the wishes of the deceased. You can have more than one executor. And what we recommend when preparing will documents is that you just don't have one executor, but you have alternative executors, just in the event that the one that you've chosen or selected is unable or unwilling or has predeceased you. So it's important to make sure that you covered that base. But the other thing, of course, is you can have as many executors as you want, but realistically, you don't want to have more than 2 or 3. And generally speaking, it really depends on the family nexus, because that's what really dictates who will be the appointed executor or executors. And especially, for example, if you've got a family of which there are 5 or 6 siblings, you can imagine that 1 or 2 might get upset that they weren't nominated. So you've got to be careful how you deal with the family politics when drawing up a will.
With the executors, do they actually get a portion, or can they claim a portion for their services?
Yeah, they're entitled to make a claim for remuneration. Generally speaking, it runs around 2% of the asset value of the estate. It's very common for a lot of executors not to make a claim for a remuneration. Or the alternative, if they want to, and there's some resistance by the beneficiaries, then they'd have to make application to the Supreme Court of Victoria to seek that remuneration.
Okay. With that remuneration, is that taken at the beginning of the process or the end? If
At the
you
end.
go down that path, the
At
end.
the end.
Yeah, with the remaining assets. Is that after the assets have been dispersed?
No, because that's where the remuneration is paid out of the assets.
Okay.
That may comprise of cash, property, and the like.
Okay. Well,
Just
this is
Lena, I had about that. Is it so? Can the executors be? Can it be lawyers or sort of professional people? Do you see that very often?
Yeah, look, you do. It's very common, especially where you want to avoid any family tension by appointing one family member against the other. We have a situation in my office at the moment where an employee of mine was the alternate executor, and the first executor didn't want to renounce his interest as executor. So my employee has sort of now taken that role. But we have a practice here that we don't charge the estate for his remuneration because of the fact that we are the solicitors to the estate and will be paid according to the scale that's issued by the Supreme Court. But it's not uncommon and it's wise. And depending on the size of the estate as well, it depends on who's the beneficiary, because if you've got young children, for argument's sake, they're under the age of 18, and you want to make sure that your assets are being carefully controlled and administered and properly invested, then you may look at professionals like accountants or investment advisors.
I've got a question. What happens if the executors, it's not uncommon for people to have arguments, etc., over wills, and it sometimes gets quite difficult for executors, and they throw up their hands and relinquish their responsibility, so there's no executor to that particular will. What happens then?
Well, there always will be, because what will happen if an executor announces his or her interest to be appointed, then, and in the absence of the will providing for an alternate, then what will happen is an application is made to the Supreme Court Probate Division, and either the state trustee's office will be appointed or some other party will be appointed. But the likelihood is that the state trustee will be appointed to act as the executor to the estate. And
then they take a percentage of the estate, don't they? For this,
they take a very healthy percentage.
Yeah. Okay.
And it's very wise not to, in my experience, and my opinion is that you're better off making sure that you've got alternate executors, state trustees. As you can appreciate, they look at it differently and they maximise their opportunities.
Okay, so it's probably wise that if you have appointed executors to make sure that they know what they're in for, basically.
Yeah, that's a good point. It's good to know that, you've chosen somebody and that they're agreeable. But the reality too is that you've got, and I don't want to put it in this sort of context, but you've got your typical mum and dad type wills, where a husband will appoint his wife, or a partner-to-partner situation. And if the partner predeceases or fails to survive, then it goes to the children. Again, depending on the age of the children, will depend on who ends up being the executors. But then you look at the more complicated situation where you may, a will maker may not have children, or then they look at who they want to gift their assets to. Then you look at the concept of the testamentary trust. Again, depending on the size of the asset pool, it will depend on how it is distributed. Okay.
I mean, look, we're all on Zoom tonight and videos, etc., and we've all got used to that type of communication. But can you make a video will, and is it legal, or do you do both? Or can you do
during the pandemic period, there was legislation that was introduced that allowed for alternative method of execution, and that during the pandemic period, it was covered by that legislation. I will be honest and say to you that I'm not too sure of its current status, because the emergency powers, I think, expire in June or July. And I can't indicate to you at this stage what the intention would be after those emergency powers have lapsed.
Okay, they call it a living will, don't they, Nick?
I haven't heard that expression, but at the end of the day, there is a method as to how you actually witness the will.
Mhm.
And a solicitor responsible is required, especially to record if it's done through FaceTime or through Zoom or through, and then also we also prepare what are called affidavits of execution, just to substantiate how the will was prepared and properly witnessed.
Okay, so who can actually contest a will, and has the laws changed in over the recent years?
Yeah, under the Administration and Probate Act, there is, you could say, a restriction as to what type of person may make a claim against a will. And I think what's very important, that the eligible person, as it's described under the Act, could be a spouse or a domestic partner, obviously adopted child, a former spouse or former domestic partner, a caring partner or carer, a grandchild, or a person who can demonstrate that they have been dependent upon the deceased for living over that period of time before the deceased passed away.
Okay. There are situations where individuals have been married or in relationships with more than one individual, so it could be 2-3 times. And how do you make a will where perhaps in a situation where you've been married 3 times and there are children as a result of each of those marriages? Because I think that complicates things, doesn't it?
No, not necessarily. I've got a situation at the moment where a client of mine has fortunately been married 3 times. He's got 2 sets of children. A will document is really a reflection of your wishes. So realistically, it doesn't matter how many children you have and from how many partners. The bottom line is how do you intend to distribute your assets and to whom? Now, what's important, of course, is that if you give a small percentage to one child as opposed to a substantial percentage to another child, that may give cause to a potential claim. But that will depend on the merits of that claim, of course.
Okay. Is there any such thing as a non-contestable will?
No, very simply
Is
put.
that the short answer?
No, well, it's a short answer because a category of people that I mentioned that are entitled to make a claim can make a claim. The bottom line really depends on whether there's merit in that claim.
Okay, so when you say merit, for argument's sake, if you've been married once and the spouses, you've made provision as a result of that separation for funds to be given to the children, and then you marry again and and if you die, you redisperse your estate and funds again. Can that first child then contest?
Because they'll be an eligible person under the Administration and Probate Act.
Okay, all righty. Okay, very complicated.
Lena, I had a question about that. So wills many years ago were not contestable. Is that the case? And then the law changed, I don't know, 20 or 30 years ago. Is that the case?
As long as I've been practicing law, Justin, I can assure you, lawyers have been very have benefited greatly out of will disputes over the decades. And a will back in those days, it was easier, most probably, to make a claim to adjust a will. But recently, and I say recently, the last about 7 or 8 years, they did refine the type of category of person that was entitled to legitimately make a claim.
Okay. With superannuation, can you actually make a will within that? And then would that make that particular, the beneficiaries that are contained in there, I've heard that if you do that, it's less contestable if you're making a will within superannuation.
Well, I think the important thing, and Justin most probably would be in a better position to elaborate on this, but if you are a member of a superannuation fund, you should be advised or have been requested by the fund to nominate a specified beneficiary who will benefit from that fund. In a funny sort of way, technically speaking, if you don't nominate a specified beneficiary with the superannuation fund, the superannuation fund doesn't necessarily have to distribute to the estate. That's why it's very important that if you're a member of a super fund, you should fill out what's called a specified nominated beneficiary form. And we adopt the view that it's to be secure that in a will, you should always reaffirm or declare that any benefits that you have in a super fund should be given to the beneficiary that you wish to nominate.
Yeah, Lena, so self-managed super funds have a form that needs to be signed by members, I think every 3 years, called a binding death nomination.
Yeah.
And in many cases where there's spouses or partners, they say, well, I give 100% of my superannuation to my husband or wife, and we had one recently. And what that means, it enables the preservation of the money to stay in superannuation rather than coming out of superannuation. And that, from a tax point of view, which, without going into too much detail, is more beneficial for the families, because it stays in superannuation, pays less tax than other sort of structures and individuals. So, and especially if it's in pension mode, so it allows the money to stay in superannuation and be transferred across to potentially the other member of the fund, or potentially some other beneficiaries, depending on what the nomination says.
Okay, so is there tax payable when you pass away under your will or your estate?
Okay, I might answer that one in relation to a will. So estates generally have a couple of years, Nick. I think it's 2 years in which to, they can go on for longer, but you're meant to sort of have the affairs sorted out within a couple of years of when we'll have questions at the end too. So I've just got some messages coming through. So we'll come back to some specific questions that people have about topics that we've run through. But essentially, so 2 years, and what happens in that period of time is the estate. So what happens if you pass away, and then from a tax point of view, the estate has to register a tax file number. So if I passed away, the estate adjuster Mastores has a tax file number, and essentially I do a final tax return, or my tax agent does, and then the estate will pay tax on income that generates throughout that period of time before probate is issued. I'll let Nick explain what probate is. It's like the finalisation, and then it allows the distribution of the capital and the income out to the beneficiaries per the will. Do we want to describe what probate is?
Certainly. In essence, when a person has passed away and the will is then sort of released, and the nominated executor has an obligation to make an application to the Supreme Court Probate Division for what's called an application for grant of probate. Grant of probate only applies where there is a will in existence. If there's no will in existence, then one applies for what's called letters of administration. And the person that applies for the letters of administration is called an administrator, and that person will be the next of kin of the deceased, whether it's a husband, wife, partner. If there's no partner, then it would be maybe child, brother, whatever the case may be. But what's important in both applications, the executor or the administrator is required to, first of all, obtain as much information as to what assets and liabilities existed of the deceased. Then will be required to complete an application for grant of probate. And in that application, the executor and the administrator signs an affidavit setting out that they've truly collected the information, and they attach what's called an inventory of assets and liabilities, and it sets out what assets exist in Victoria, what liabilities exist, and any assets that existed outside the state of Victoria, whether New South Wales or overseas. Once the other important thing is that you can't apply for an application for probate or letters of administration until you've advertised. And generally, you'd find them in the daily newspapers that solicitors will publish these notices and to the world at large, and that they propose to make application 14 days after the advertisement period has elapsed. Once that's occurred, you lodge the application. The registrar of probates is responsible for assessing it on its merit, on what is submitted. And generally speaking, it takes 7 to maximum 14 days, in my experience, for a probate or letters of administration to be approved. The registrar does have the power to sort of requisition if he feels, or he or she feels that there's certain information that they require, more information they require to sort of be satisfied that the estate has been properly administered. That, in my experience, occurs, I won't say it's a common occurrence, it's not a rare occurrence, it's not uncommon for the registrar to ask requisitions, but generally speaking, it's about a 14-day period. And once the grant's been approved, we get a beautiful document called a parchment, and it's got the seal. So we go back to the old Westminster system of doing things, or back to England. But the bottom line is that that's when the executor, through the assistance of the lawyer, will then proceed to call up the assets of the estate, or more importantly, follow the instructions as set out in the will.
And the will is not, or the actual beneficiaries do not get any of the benefits of that will until that probate's passed, correct?
Number one, but number two, under the, it is wise that an executor does not distribute any of the estate to some period after. Now, the reason being is that somebody may wish to make a claim against the executor on behalf, and generally there's a rule of 6-month period. So it's not uncommon for an executor not to distribute until that 6-month period has elapsed. However, in practice, it's fair to say, especially if it's, say, and again, I'll use the simple example, husband to wife type situation, and you've got 1 or 2 children, there's no argument, and they just deal with it.
Okay. What types of power of attorney would you recommend that one put in place?
Powers of attorney, as you can appreciate, are separate to that of a will. A will document is basically there for when the will maker passes away. The power of attorney is a document that is operative during the period that somebody is alive. And in Victoria, we have legislation that covers the type of powers of attorney that should be applied for or utilised. And the most common are the medical power of attorney, and then there's the enduring power of attorney, which really relates to general matters, but more importantly to one's financial concerns. What's important with the power of attorney is that once you've nominated a person to be your attorney, that doesn't mean that that person can immediately rely on that document and start making decisions on behalf of that person, because the only time that a power of attorney should be adopted is when that person has no longer the mental capacity or the capability of making a decision about their finances or about their own medical condition.
So,
go on. Sorry.
I was going to say, so that you don't have to have a separate power of attorney for medical and finances.
No, you do. You've got separate documents.
Okay. Okay.
And maybe just we had a question on wills rather before we move on to the other section, Lena. Stella asked a question. So I mentioned about a period of time, a couple of years. So the question, Nick, was can money stay in an estate and essentially the estate stay open so those funds can be used at the executor's discretion, say for the care of a beneficiary, for example?
Well, it can. It depends on what the will document has directed the executor to undertake. But yeah, there's nothing stopping an estate living beyond the 12-month period or 24-month period. You'd be better informed than I would, but the estate ends up being a taxpayer.
Yep, it does. And it gets taxed like an individual.
So there's nothing stopping it. And it's not uncommon for that to occur.
Yep.
Okay, just before we move on to estate planning, I've just got one other question. What happens if an individual dies, hasn't got a will, and the children are still living in the house, adult children, and that just continues. Is there a cut-off point? Do you need to, does state trustees get involved? Then what happens in that situation? Or is it up to the...
As I said before, in the event that a will does not exist, then one applies for what's called letters of administration.
Mm-hmm.
And the administrator that's appointed will be the next of kin. So depending on the deceased circumstances, whether they have a partner or not, the partner will be obviously the first person to be appointed. If they don't have a partner, then you talk about children. If they don't have children, you talk about a brother or a sister.
So it actually goes in layers, Nick. So it goes to partner, children. If there's no children, then could be next.
You follow the next of kin.
Okay.
So, and the bottom line, if there's a primary residence involved, you've got up to 2 years in which to deal with the primary residence. Now, then it becomes an investment property. And again, Justin will be in a better position to sort of elaborate on that point than I would. But a 2-year period is very important for primary residences because of the fact that it escapes being treated as an investment property and attracts all capital gains tax issues, land tax issues and the like. But it depends, again, with in the absence of a will, it depends on who is the beneficiary, at what age they are, what their circumstances are.
Okay, thank you, Nick. Now, Justin, if you could, answer a couple of things here in relation to estate planning, how would you define it?
Estate planning, I would define in my own words as standing back from a family's situation, let's call it husband and wife, and we've just been talking about wills, which is a document that prescribes how your personal assets will be distributed, if you like, upon your death. Estate planning is taking a little bit more of a broader view, Lena, and that is really looking at all of the assets, all of the structures. So there's a lot of people around the country and even on this call that have family trusts. So it takes into account the family trust, the superannuation fund, and also to any other investment vehicles, potentially investment companies and other investments as well. And actually looking at that and having a plan around how the assets will be succeeded or passed on over time. So some estate plans for families are all about keeping assets in family trusts, and we'll talk about trusts a little later on. In other cases, the estate plan for a family may be to distribute an amount of the estate every year and then keep another percentage that must stay within the control of those who manage it. So estate planning is not just looking at your will, but looking at a much broader situation, taking into account and having specific advice with lawyers involved to actually put a plan around what happens if you're not around in relation to all of your structures.
Okay, so what would you say are the 3 common mistakes when people are estate planning and when they've got, a family trust, super, self-managed super, investments, structures and companies? What do you see that they overlook that are really important to get right?
Yes, and the first one is not involving both your lawyer and your advisor, whether they're an accountant or another trusted advisor. So having the parties talk and exchange information so all parties are aware of all of the assets and structures that are in existence. Some people have different trusts that they set up for each different development or asset that they purchase. So we've got clients that have 50 or 60 entities in their structures. So the mistake is not communicating between the advisors to actually get all the information down properly. I think an estate plan, like a will, Nick, and you'll back me up on this one, it's almost like a living document as well. It's not something that just goes in the bottom drawer. It gets reviewed, especially with sort of business type people. It gets reviewed every year to make sure that we're covering off on all the moving pieces and items that have changed, whether it's family, investments, structures, all those sorts of things are taken into account. A third one, Nick, any other sort of pitfalls that you can think of?
I think the major pitfall that I've experienced over the years is people's understanding about how they deal with their family trust in a will. It's got to be said that a family trust is not like a piece of cake that you can divide amongst beneficiaries. All that you're doing with a family trust when you're drafting or preparing a will document is passing on the management and control of that trust. And that's something that's very important. I remember many years ago, I had a client of mine that was quite comfortable financially, and he wanted to divide his family trust. And I indicated to him there's no way, and he couldn't understand it. But the bottom line is that people must appreciate that if they do have a family trust, you can't just cut it up in pieces, but all you are doing is handing over the baton of management and control, which is one of the strange, especially for an older generation client base that was just told to put things into a trust because they're, without being disrespectful, just because their accountant told them they would do it, but they didn't realise that what a trust really meant. So that's number one that we face. The pitfalls are really trying. A number of people still wish to dictate from the grave. That's always a problem. How they'll be able to still manage their financial affairs while they're not around. And the third one, which is very popular, is do you trust the in-laws? The problem is that they want to leave something to their children, but they're worried about the son-in-law, the daughter-in-law, or the partner-in-law. So the problem that you've got there, of course, is that there's certain restrictions because you want to give in one breath, but at the same time, people want to avoid to make sure that the in-law does not get the total benefit, especially if there's a separation between partners, which is very common. I mean, I can tell you now in the last, it's a common question that I think gets raised every time we do a will in this office.
Yeah, I'd imagine it would be, Nick. Yes, it would be. All righty. So I think we've covered what a family trust is and why you should have one. In terms of estate planning, it's really it's a broader vehicle to look at and get your lawyer and your advisor involved. But what are the costs in running a large trust, Justin?
Yeah, so I might just go back one step, just in relation to the family trust. Nick
Yep.
touched on it. It's not a pie that can be divided up. I often use the example that essentially every farm in Australia, but before half of them were bought by people from north of the country, every trust in Australia is held in a family trust. And the reason for that is that generationally, those assets wanted to be handed down from father to son or daughter. So family trusts are separate legal entities. They can't exist without a trustee. It can be an individual or a company that's the trustee, but separate legal entities that were established under English law that allows you to accumulate assets and borrow money if you need to buy additional assets in the future. But essentially, for clients and people that want to build assets over time and pass on, as Nick said, the control, not the assets, but the control of the assets, and then ultimately the control of the income of those assets to the beneficiaries. So a beneficiary of a trust is generally related to a specific beneficiary. If you use me as an example, of people in my family related to me. And then the trustee of a trust can decide of the people that are related to me, who's going to get what income each year. So a trust doesn't hold on to income. It has to distribute out its income every year. Otherwise, it pays tax as a top marginal rate individual. So it pays tax at 47% every year. So that's probably a differentiation to a company or even an individual, is that the trusts continue on for a period of, it's actually 80 years.
Okay, that's very interesting. Now
Sorry, I didn't answer your question about costs. Sorry, Lena.
So go on.
It depends on the size of the trust. So trusts cost money to set up, and it depends on the type of trust that someone wants to set up. It's generally anywhere between sort of $2,000 and $5,000 to set up a trust, depending upon the complexity around the trustee and everything else. And it's a Victorian trust, and it's got to be stamped at the State Revenue Office. And then there are annual costs. So a trust has to lodge prepare a set of financial statements, lodge a tax return, and take advice along the way. So it can be thousands and thousands of dollars to run a trust. So you've got to have either the pool of assets that you want to put into the trust, or the assets or be building the assets at a relatively steady rate to warrant the cost of setting up this separate legal entity.
Thank you. Thanks. That's great. I just wanted to ask another question. I'm going to go back a little bit in terms of executors, and, you know, wills, and when people pass on, and, you know, there's always room for people to dispute, etc. So I don't know what you guys think. Is it better to have, you know, a lawyer and an accountant as your executor to administer your will, your wishes under that will? Because a lot of people put family members, and, you know, they pick someone from one side and the other. What would you say, or what would your recommendation, and bearing in mind that, you know, we're just talking here, what have you seen the best way to go about that? Because as I said, a lot of people just put their family members in, and that can open up arguments all round.
Lena, it really depends on the family climate at the end of the day. A lot of clients that we're prepared wills for have total faith or trust with their children or their spouse, and there's no issue.
Mm-hmm.
So it's a difficult question to answer because it really does depend on the circumstance that prevails at the time. I think the larger the estate and the more complicated the wishes of the deceased or the will maker, does give good cause to have an accountant or a lawyer to be part of the decision-making process. But it really depends, because you've got a small estate, you don't really want to start incurring unnecessary costs. But if you've got an estate in which you want to ensure that the beneficiaries enjoy a long-term, if not multi-generational benefits, then you look at a different structure. A classic example of a very different structure is the old Meyer family. The Meyer family established their own trust office in which their substantial accumulated assets were preserved, but the very many generations of Meyer members have enjoyed substantial dividends over the years. So it really does depend on the size of the cake, really.
Okay. Justin, is there anything you'd like to add?
Just around, I think, as Nick said, you know, having professionals involved when your affairs are more complicated and the estate is potentially larger. You know, if I use myself as an example, my wife and myself have, one of the executors is someone who understands the financial, you know, he's a very close friend, understands the financial complexity of our lives, and then the other executor is someone who understands probably the children and the family dynamic as well. So we wanted both of them. So it really is horses for courses, as Nick was saying. It doesn't have to be your lawyer and accountant. It's really, well, who do you think understands your affairs best? And then is, as Nick said, is it your spouse who, you know, you trust 120%? You're happy with them running everything in your passing. So on your passing.
Okay. Well, we've covered quite a range of topics here under wills and estates and trusts. We probably could go on for another hour. And before I open it up to everybody to ask individual questions and answer some questions I think that have come through in the chat line, Nick, is there anything else you'd like to add before we do that?
Look, the only thing I will say in conclusion is that a will document is not necessarily a complicated document. A will maker just needs to be certain as to who they wish to distribute their assets to, and to be clear in who they wish to appoint as their executor or executors. And don't sort of dictate from the grave, as I said before, because you can actually plan the arrangements quite clearly. Leave the Word documentation to the lawyer to translate into plain English, and that way it will make life easier. But there's one thing I can say: there is no guarantee that a will not be challenged, because it's something that you can't avoid if a eligible person feels aggrieved.
Okay, well, look, thank you very much to both of you. I'm sure that there's lots of questions and it is a complex area. So if Carolyn, you could kindly unmute everybody. And
also in the chat box as well, then if people want to ask an anonymous question, if you just tap on the chat function up in the options, or the little dots depending upon what you're on, and you can just hit chat and actually type a question to everyone if you want to ask an anonymous question. Lena?
Yep, that's wonderful. All right, Carol, if you can, and I'd kindly ask you to sort of pop your hand up so that everybody's questions get answered. So Carol, if you can unmute everybody now, that'd be wonderful.
People are free to unmute themselves if they'd like to speak, but otherwise stay muted in case of that.
Okay, all right.
But we have Michael who has raised their hand. You might want to ask a question. Yeah.
So Michael, if you'd like to ask your question. Michael.
Hi, Michael or Mike?
Mike. Mike, there's a Michael's iPhone and a mic. Have you got a question, Mike?
Yeah, I do. Question to cousin Nick. Two-part question. Do you think Yaya Paniota should have listed a kakamari recipe as an asset in her will? But in a little bit more serious, in a sense of context and history, what did they used to do back on Kazzie in the old days about these sort of? I know we have a lot of traditions and things like that, but how did these sort of things, these matters get handled back in our Buffalo's generation and earlier, before we came out of this country?
That's a good question, Mike. I'm not too sure. I think they would have relied on the donkeys for advice. But,
I guess they would have used tradition, Nick. Would they have just followed the fairly...
I mean, it's interesting because you got to remember that the island was administered by other jurisdictions as well. So I'm not going to say to you with any certainty how the Italians would have managed things, and prior to them, how the Turks would have managed things, and prior to them, whoever. However, there's no doubt that in Gustalorism in particular, it's like Murphy's Law. So
I'm guessing they weren't short of opinions, to speak, Nick.
No. We're renowned for that.
I don't think confidential reality would have been too big a deal either, would it?
No. But I think our Yaya Panayota's underwear was the most cherished asset, because it was
from my memory, it was a sizable asset from my memory too. Yeah. Having seen it on the line at Dirk Costello's a few times.
That's true.
Thanks, Nick.
Thank you.
Okay, Lena, any other questions in the chat? I can't see anyone want to raise their hand.
Carolyn, you're actually able to see them. I can't see them.
There aren't any more hands raised.
I've actually got my hand raised.
Your video is off, so we can't see that.
Let me just try and fix that.
Who's that?
Stella? Is that
Stella, yeah. I'll just try. Okay, haven't done many Zoom sessions.
Thanks for joining us, Stella.
Thank you, and thanks for having me from Sydney.
You're welcome.
I love your Kazzie Connect.
Oh, thank you.
I love reading your newsletters and everything. Anyway, so if I could please ask my question a bit, what I've put in my chat, if I could elaborate a little bit, is that okay?
Yeah, sure.
Okay, so basically in my current will, which was drawn up with a lawyer and it was done a few years ago, and I want to update it. So I do have in there that I'd like to keep some money aside for one of the beneficiaries, but to be kept in the estate, and therefore the executor having discretion when to pay that out as the need arises. However, now that a few years have passed, and as I've been looking more into wills and estates and trust funds, etc., and I'm not in favour of trust funds for the little bit that might be, I'm trying to get my head around how can I fix it up better. So basically I want to leave some money, like I'm talking a couple of $100,000 probably, leaving a couple of $100,000, the rest gets dispersed, but a couple of $100,000 to leave in the estate for when that beneficiary needs it. And that beneficiary will need it over time, but not right now.
Are you leaving the discretion
to the executor?
Yeah. What's important is really the executor has an obligation to make sure that he or she invests that $200,000 wisely.
Yep. So
that you can maximise the return. And in Victoria, there are certain powers that a trustee, an executor has, and must sort of work within that framework, because if they work outside that scope, they could obviously be charged with being negligent or in mismanaging the estate. But depending on the wording, if you're giving an executor a discretion to apply funds to when that beneficiary requires those funds, then it's a bit of an open door for that person, unless in your will you can establish certain criteria that need to be satisfied before the money is released. But at the end of the day, if that, in the absence of that criteria being sort of set out in the will, the executor has a legal obligation to make sure that they're applying those funds correctly, reasonably, and in the best interest as stipulated by the will maker.
So I don't have a problem with the executor. So then what I'm concerned about is the 2 years.
The beneficiary may have a problem in the longer term.
Maybe, but the 2 years that you mentioned, so is it quite okay then not to have the trust fund, just to leave the money in the estate, and that means that the will would be going on for many years?
Yeah, that's not a problem. Disregard the 2-year rule for the purpose of this, for the purpose of your example, because of the fact that in the will, you are directing the executor effectively to invest that capital for the purpose of advancing the welfare of your beneficiary, and therefore applying those funds at his discretion in a manner that will obviously hopefully look after the interest of the beneficiary.
So in terms of who owns that money, it's still the estate that owns the money, and therefore any taxation?
Again, depending on how it's worded, but any income derived will be for the benefit of the beneficiary.
It has to be distributed to the beneficiary, does it, at the time?
No, if it's not distributed to the beneficiary, then it will become the estates, and the estate will be liable to prepare a tax return. If it, however, is distributed to the beneficiary, the income that the beneficiary receives would need to be disclosed.
So what about if the income stays any, say the 200,000, it's only very much, even if it goes to 5% interest, for instance, that 5% each year just stays in the estate and as building up the asset until that person needs it, is still tax payable?
In my view, Justin will be in a better position.
47% of the income after year 2 would be taxable. You would be paying tax at 47%.
By the estate?
Yeah, so if it was $10,000, the estate would be paying $4,700 a year in tax, correct?
On the interest only?
Well, only on the interest, not the capital. So the whole, my understanding of the law is the whole idea is to distribute out the assets and have the individuals, the beneficiaries, deal with the income and all, gains. But they're happy for, well, the law is such that they're happy for the estate to continue, but it then costs to lodge a tax return, and then it has to pay tax on the income that it has each year. That it doesn't distribute, the income it doesn't distribute to beneficiaries.
Yeah.
Okay, so just on the interest though, there's only tax payable on the income that is generated, yep?
Yes.
Okay, thank
Stella,
you.
what's important, if the distribution is made to the beneficiary, then the beneficiary will be taxed on the amount that he or she receives.
And what about if it's just a lump sum for a specific purpose at the time that it's given to the beneficiary?
Depends if it comes out of the capital or whether it comes out of the interest.
Or the income.
Yeah, if it comes out of the capital that's built up, there's no tax payable on that, I would presume.
No.
Okay. Now, may I ask a separate question on trust funds?
Sure.
Thank you. I did look into trust funds about 2 or 3 years ago when one of my family members was setting something up, and I didn't think it was applicable for their use, and I'd just like to have that confirmed in my mind. 2 children, all the money from the parents goes into a trust fund. I'm not talking large amounts of money, it's basically from a family home. Money goes into a trust fund. 2 children involved. Children want to buy houses. They won't have any other inheritance except what's in the trust fund. They both want to buy houses, and what I was looking at, you don't always get a loan because lenders don't seem to like trust funds. And then you've got the partners involved as well. So how do you get a loan anyway if you want to buy a house? when there's
So
two
in
children
short-
involved.
In short, if there's only so I use the example of a family from Adelaide. If there's only a family home, there wouldn't be a need to have a testamentary trust will, because you want essentially the asset passed to your children. They might keep it as a rental property, or they may sell it. Generally speaking, when there's a lot of assets in an individual name, then there's potentially the need for a testamentary trust will or a non-simple will.
I totally agree with that, but that's not what's happened. So thank you very much.
Okay, thank you, Stella, for asking those questions. I'm sure that people got a lot out of that. Is that you, Mike, with Michael's iPhone? Oh, Michael, there, I can see you. Yes, go ahead and ask your question.
Yeah, sure. Justin, you spoke about self-managed super funds, and in this case, there are two members, and the same two members were the trustees. One of the members passed away, and he didn't have a document that you spoke about. I forget what you did call it.
Binding death nomination.
That's the one. What then happens with his share of the super fund?
Did the person have a will?
Yes, he did.
Yeah, so if the will, Nick, my understanding, if the will identified the nature of how the super was to be handled, it would be handled per the will. I'm not sure if there was no will and no binding death nomination, what happens, to be very honest with you.
Well, there was a will, but I don't believe there was anything mentioned about the super fund in the will. And there was a trustee company involved to handle his estate, and they took his section of the super fund.
Well, it would, generally speaking, you have a general will that says, I give and devise, bequeath the whole of my estate of whatsoever nature and wheresoever situate to so and so. That includes any benefits that may be derived from a superannuation fund. But as I said earlier, we have an anomaly when it comes to the treatment of superannuation monies, because technically a trustee does not necessarily have to distribute to an estate unless there's a nominated beneficiary form completed. Now, in practice, it doesn't occur that way. So I'd be surprised that the superannuation funds were not treated as part of the general assets of that beneficiary. And it sounds unfortunate that the State Trustee's Office has taken the lion's share of that.
It wasn't State Trustees.
Oh, sorry.
It was another. It was ANZ Trustees.
Okay, or an institution.
Yeah.
Sounds a bit odd.
It does.
But they took his share and put it into his estate.
Well, they did put it into his estate, and then it
Yes.
got distributed.
Oh, that's all right.
That's correct.
Yep. Okay. Thank you.
Yep, that's correct. Sometimes, we've seen situations just to that, Michael, just to that point where, so I might have a will that says everything goes to my wife, but my binding death nomination might say that, well, only half my superannuation goes to my wife, and then 25% of my super to my brother and 25% of my super to my sister. So sometimes that's why the super funds have a separate binding death nomination, and the advice is you should always have that. And as Nick was saying, the intent around where you want your super to go should always be reaffirmed in your will.
Yeah, well, I've got that binding notice for my fund, because I'm the only member left in the fund now. So, okay, thank you very much.
Pleasure.
Nick Spartels.
How are you, mate? How you going? Nico, well done tonight.
It's been Nick.
Another cousin, that's a worry.
Yeah. Look, I just want to ask a question. I've actually got a mate of mine whose father just passed away, and his sisters, the two sisters and him, have been left the house, a big house in Brighton. He's been, obviously, the parents were living in it for about 40, 50 years. Now, he was talking to me this morning, telling me that if they don't sell the house, but that they have to pay capital gains tax after 2 years if they don't sell it within 2 years. Is that correct?
That's correct.
It is correct.
If it goes up in value.
Yeah.
Well, yeah. Well, the problem is this house is costing them 16 grand a year just on cancel rates, so they haven't got income coming in. Obviously not they're asset rich, so that's why they need to sell it. But he was just telling me if it's not sold within the 2 years, capital gains becomes applicable. So I was shocked at that.
But Nick, you've got to remember that at the time of probate, let's say, they would have attached a value to the property, let's say $2 million.
Okay.
In 2 years' time, or after 2 years' time, if they sell the property for $2.2 million, then the capital gain will be on the $200,000.
Yeah, not the original. Sometimes there is no increase in value, but generally the probate valuation is conservative, and that it sort of gives people a bit of a little push along to make some decisions about the asset, or if there's two kids and one of the beneficiaries that wants to buy the other one out or something along those lines, it gives them time to do that.
Yeah. Okay. Interesting. All right. Thank you.
It's not just the family home; it's also too if there's other, so BHP shares sitting in there and they're there for longer than 2 years. It's when the probate was issued, what was the value of the BHP shares versus 2 years later when they got sold, and then the estate would have to pay the tax, capital gains tax.
Okay, that's fair enough. Okay.
Not really, but it is how it is.
All righty, well, we're just hitting on 8 o'clock, and I'm actually just got one question I want to ask that was touched on before by Michael. I'm not sure if it was Michael or Stella, in that if you are leaving money in a trust and individuals then, as Stella mentioned, want to buy a home, she mentioned, I think, that banks don't like, you can't leave that trust, or what's the situation with banks and trusts?
Yeah, banks don't like testamentary trusts, so where you're getting income from a trust that was set up in someone's will, generally speaking. They don't mind, they look at, an investment trust that's been around for 15 or 20 years accumulating assets. They look at that and look at the income that they're okay with it. It's when someone's relying on income from a testamentary trust, they don't like assessing that and then using that income, in Stella's case, using the income from that trust to assess a loan. So as I was saying, those testamentary trust wills are generally when there's more complexity around the sort of value and structure of those personal assets. When there's a lot, like an old Greek that's been buying property since the 50s and has $25 million worth of, investment properties in their own name, a testamentary trust might be relevant in that case.
Okay, thanks, Justin. Well, look, I think we'll wrap up now. And look, that was absolutely fantastic. It's a complex area. At the end of the day, no will is airtight, so you can only do your best. So I wanted to thank you, Justin. It was wonderful hearing from you. And again, congratulations on being our new president. And Nick, thank you very much for all the work that you've done for the KAV, and we certainly appreciate it. And we appreciate your time tonight, Nick, as well. And again, I just wanted to reiterate that anything that the guys have talked about tonight is just purely conversational. If you need, don't take it as advice. Go and seek out your own professional to take it to the next step. So unless anybody's got any further questions, we'll wrap it up now. And I want to thank everybody for joining again. The next Kazzie Connect will be in about 4 weeks in June, and we're hoping to get Dr. Philip Antippa to speak to us. And that, I believe, Nick, he's a heart specialist, correct?
Yeah, heart and lung, yeah.
Yeah, I thought it was pretty opportune in the light of, recent events with various cricketers dying of heart attacks and other people that we know. So it'd be good to get his perspective on good heart health. And then in July, when it's all getting cold, etc., we're hoping to go directly over to Castellorizo itself, and where Michelle Kiotsoglis will join us, and we'll be able to talk to her about properties, etc., over there, where you can ask some burning questions again. So I want to thank you all again for the support you've given to Kazzie Connect, I'm really pleased that we've had a great presence tonight, and we'll close it off. Justin, is there anything else you'd like to say or add?
No, just thank you to Lena for hosting tonight and keeping the Kazzie Connects going.
Oh, my pleasure, absolutely.
Lena.
All right, guys, you can stay on because Kazzie Connect is all about talking. So if you want to stay on now, we'll leave it open for the next 15 to 20 minutes so you can chat to each other. But apart from that, thank you very much on my behalf and on behalf of the committee and president for joining us tonight, and watch out for June. Bye.
Enough.